All right. Hello, everybody. My name is TJ Scott, or Timothy Scott. I'm the owner of the law office of Timothy J. Scott, and I'm located in Bloomington, Minnesota. I'm so happy to have you here today with me learning about this topic, learning about estate planning and learning about wills and trusts and guardianship and all of these different things. What do they mean? I promise we're going to talk about that today. I know for a lot of us, this is a really difficult topic. It's tough to talk about incapacity, and it's tough to talk about death and what's going to happen with our family after we're gone. But I believe that knowledge is power. And that's what I want to give you today. I want to empower you. I want to educate you. And I want to give you some peace of mind around this difficult topic. So today I have some really valuable information that I'm going to share with you. And I have some valuable offers at the end of the presentation. So I hope that you'll stick with me here tonight. The best way to learn is to be present with me. Turn off any distractions that you have around you and give yourself this time to learn about this topic. Estate planning can be complicated. There are a lot of moving pieces, and it's legal and related to the law. And so, as you can imagine, there are some complexities here. I'm going to try and boil it down and make it as simple as possible, but the best way to learn this information is to give it your full attention. And I always say your future self is going to be grateful for the time that you took here tonight learning about this topic. And if you stick around until the end, I have a couple of offers that I want to give you. The first offer I have for you is how you can get a free virtual one-on-one meeting with me where we can talk about the people that you love and the state's plan for you and for your things and how you can make sure to protect them. Plus, I have a bonus gift that I want to give you to make it even easier to get a personalized and tailored estate plan in place with me. But before we go too far, I want to ask some poll questions. And the first poll that you should see here in just a second is the question, do you have an estate plan? What is an estate plan? A lot of people hear that and they think, well, I have to have a will or I have to have a trust. And the reality is that an estate plan includes those, but is so much more. An estate plan is going to include a will. It's going to include guardianship nominations if you have minor kids. It's going to include planning for incapacity as well, things like a healthcare directive, power of attorney. But it goes even beyond that to things like beneficiary designations on your retirement accounts and life insurance policies, making sure that those assets are going the way that you want them to. And I'm seeing overwhelmingly people say that no, they don't have an estate plan in place right now. And my guess is for a lot of you, that's why you're here, is because you want to learn about this and you want to see what does it take to get an estate plan in place. And so I really thank you for sharing with me in that poll. I have another poll here. If you don't have an estate plan in place, you're not alone. Don't feel like you're completely alone. In fact, something like 69% of Americans don't have an estate plan in place right now. And maybe one of the reasons here resonates with you. Maybe you feel like you're too busy. And I do see some people saying, yeah, I feel like I'm too busy. I completely understand that. Life today is really busy. And I have 4 kids. I am a business owner. I completely understand life being busy. If that's the case for you, I want to commend you for being here today and taking the time to learn about this topic and exploring this topic. And I promise to give you great information today so that you're able to move the ball forward and get started on a plan to take care of the people that you love. I do see somebody saying that they feel like they're too young to have an estate plan. And the truth is that anyone over the age of 18 should have at least a foundational estate plan in place. I recently helped a young family where a father had passed away and left something of a mess behind for his wife and minor daughters. But it didn't have to be that way. It just doesn't have to be the case. You can get foundational estate planning documents in place at a reasonable cost. And that really brings me to the next point, too expensive. And I'm seeing overwhelmingly that this is a reason that people don't have an estate plan in place, is that they feel it's just too expensive to get this done. And I want you to know that I'm going to speak directly to this point a little bit later this evening. I'm going to tell you exactly what an estate plan should cost and exactly what you should expect to pay. But I also want to give you a little bit of peace about it right now and say, before word processing, estate planning truly was only for the very wealthy. It truly was only for people who had an inordinate amount of wealth because of the amount of resources that it took to hire the attorney, to create everything in triplicate. And if you made any mistakes, you had to go back and tear it all up and start again. It used to be very difficult to get an estate plan in place, but it's not anymore. It is more accessible than it has ever been, and you can get an estate plan in place for a reasonable fee. And again, I'm going to tell you how you can do that here in a little bit. And maybe you're worried about jinxing yourself. I don't see anybody admitting that they're worried about jinxing themselves, but I've heard it before. And let me just give you a little assurance on that. I have done hundreds of estate plans, and I have never seen a correlation between somebody getting their estate plan done and having something happen to them. It's just not something that I've seen, and I hope that gives you a little bit of peace. But again, there's not a correlation there. This isn't a Hollywood movie. There's not going to be some catastrophic event just because you get your estate plan completed, like the police officer on his last day on the job or something like that before retirement. So don't worry too much about that, okay? Thank you for sharing with me. Thank you for sharing in that poll. Here's a question that I have for you. If you have an estate plan in place, or if you don't have an estate plan in place, but something on this list resonates with you, I hope that you'll let me know. If you have a plan in place or something like this resonates with you, what is it that you're hoping to learn here today? Maybe you want to know if an online or do-it-yourself will is okay and it's going to take care of your family. Or maybe you created an estate plan, but that was 20 years ago when your kids were minors, and now you want to know if they're going to have to go and live with Aunt Debbie if something happens to you. Maybe you're wondering if it's outdated, in other words. Or maybe you just want to have a better understanding around this topic or around an estate plan that you had written for you, but the attorney didn't bring you along as you were getting it done, didn't include you in the planning process, and didn't educate you to make sure that you completely understood the plan that was being written for you. Or maybe it's something else and you want to share that with me. And I'm going to watch over here on the chat. I'm going to watch over here on the Q&A for anything else coming in. I see a lot of people want to understand their plan better, or they want to understand estate planning in general better. I take that to mean, and we definitely will after the end of tonight. We're definitely going to talk a lot about that. And I see some people wondering if their plan's outdated or if an online will is okay. And I can promise you, I'm going to talk about do-it-yourself planning, what I can do and what I can't do, and when you should really consider engaging an attorney to help you write an estate plan. Thank you again, everybody, for sharing in these polls. I really appreciate it. Whatever the case, wherever you are, if you have an estate plan in place or if you haven't done estate planning yet, I want to assure you that you are in the right place. You're in the right place here tonight if you have someone or something that you care about and that you want to protect. You're in the right place if you've done an online or fill in the blank will, or if you're considering doing an online or fill in the blank will, but you want to know, is this going to take care of my family when I need it to take care of my family? And you're in the right place if you're nervous about how much this is going to cost. Like I say, I promise that's something that I am going to address here tonight. I know that's important. The reality is estate planning isn't about us. And this is something that really resonated with my wife and I recently when we were updating our plan, that the estate plan wasn't going to bring us extra wealth. It wasn't going to enrich us during our lifetime, other than being a relief that we knew what was going to happen after we were gone. Really, it was a gift that we were giving to the people that we loved, and to the people that we love. And these are 3 of my 4 kids from left to right here. It's Margaret, Ben, and Elizabeth. And the truth is that they're going to know whether you lived up to your promise to take care of it after you're gone. So here are some of the things that we're going to learn today. And I do see some questions coming in, and so I want to turn my attention there really quickly as we're addressing this, and make sure that we're able to cover all of these questions here tonight. One of the questions I see is there a difference between creating a trust using trust law or contract law? That's a good question. I'm really going to be talking about the trust code here tonight and creating a trust using those laws trying to think. I know that there are I mean, a trust really is a contract. It really is an agreement that you're creating. The trick is the trust that we're going to be talking about here tonight is between two people, and you are both of those parties. You're the creator of the trust, you're the one writing the rules, and you're the person who's taking control of the assets that are being funded into the trust. And I promise you that we're going to be talking about this a little bit later, but that really is, that's what a trust is. And that's what we're going to talk about here tonight, is that a trust is really an agreement between these two parties about how to deal with property. And with that, we're able to plan for the future. We're able to plan for what's going to happen to those assets in the future. Someone else is asking, I'd like to know, how should someone without children go about planning an estate? And that's a fantastic question as well. There are a lot of questions that come up when we don't have children. And one of those is, where are my assets going to go? Where does the state think that my assets should go? And that's something that we'll talk about. Sometimes people want to know, where do you think my assets should go? And I get asked that somewhat frequently, that what do I think should happen to their assets if they don't have kids? And it's a tricky thing. You know, it's there are a lot of options. Keeping it in the family is the most typical option, but there are a lot of wonderful charities out there that would be very happy to receive some kind of an endowment from an estate as well. So we'll definitely talk a little bit about both of those tonight. And these are some things that we're going to talk about as well on the screen. We're going to be talking about planning for incapacity and how you can make sure to put in place people who can make healthcare decisions for you, people who can make financial decisions for you. We're also going to be talking about planning for after you're gone, after you pass away. And for people with minor kids, in fact, I'm going to pull up a third or a fourth poll. This is the fourth poll, but this is the last poll here. And it's kind of a demographics poll, if you don't mind answering. But I want to find out how many people here have minor kids. And I know some of the people that I talked to earlier tonight have minor kids. And so I know that this is something that is on people's mind, guardianship and planning for guardianship to make sure that those kids are taken care of. We'll definitely talk about that. We'll talk about probate, which is a court process that happens after you're gone. We'll talk about the time, cost, and public nature of probate. And we'll talk about the fact that it's actually voluntary, that you can choose to avoid probate, but you have to do some planning in order to do that. We'll talk about estate taxes tonight and unclaimed property, which isn't something that you hear a lot of estate planning attorneys talk about, but I think is really important. And we'll also talk a little bit about your intangible assets, things like your stories and your values and how you can share those. And I'm seeing most people here are either married with grown kids or single without kids, some single with grown kids and some single with young kids. And so we won't spend a ton of time talking about guardianship, but it is something that's important. And so I am going to spend a little bit of time on it here tonight for those of you who have kids. So thanks again for sharing in the poll. And again, if you have other questions, if there are other things that you want me to turn my attention to, I hope that you'll share that with me in either the chat box or in the Q&A box. You can share it. I believe there's a way to do Q&As anonymously, and I believe the webinar chat, if you're just sharing your question to the host and panelists, I'll do my best not to say the name that pops up, and that's a way to keep it a little bit anonymous. Otherwise, if you're happy for anyone to hear your question, if you're happy for anyone to see the name that's attached to your question, you can share it with everyone as well. See somebody saying married with grown kids, but also I'm the guardian of 2 grandkids. Yeah, thank you for sharing that. That's certainly a nuance and certainly something that's very important to making sure that you get a plan in place that those grandkids are taken care of as well. Okay. Before we start talking about the elements of an estate plan and talking more about that, I'd like to share just a little bit about me, since we're going to be spending some time together tonight. So this is my family. Again, we live in Bloomington, Minnesota. My wife's name is Tobin, and my kids are Ben, Elizabeth, Margaret, and Bridget. And from left to right here, we have Elizabeth. Margaret is kissing baby Bridget. And then that's Ben sitting in front of me. And my family is my whole world. I spend a ton of time with them. I graduated from the University of St. Thomas School of Law back in 2012, near the top of my class. And the very next day, my son, Ben, was born. I found a job after law school with a small estate planning and tax preparation law firm, and I love the clients that I was able to work with. I love the type of work that we were doing. Sometimes, though, I didn't feel like I was providing the value that my clients deserved. And so after a little over 3 years with that law firm, I actually ended up leaving. And this is a picture from my last day there. Someone has to graduate at the bottom of the class. Now, I just want to say this was not said about me. This was something that a family member said about an extremely negative experience they had working with another estate planning attorney. And in particular, I remember this family member saying, someone has to graduate at the bottom of the class. And there was a big reason for their frustration over this estate planning process. I don't actually think it was this attorney's knowledge or their intellect or their ability to excel in law school at all. I think it was the model that this attorney was practicing under. And I'll talk more about that faulty model. I call it planning for death later. But first, let's talk about some of the elements of a well-drafted estate plan. As I said, I'm going to talk a little bit about guardianship here, but not dwell on it too much. But there are two elements to guardianship for minor kids. There's short-term guardianship and there's long-term guardianship. And the way to think about short-term guardianship is who is going to be there if something happens when you're out on a date and you don't end up coming home. The babysitter is watching the kids and there's no plan in place. Eventually that babysitter, when you don't arrive at midnight, you don't arrive at 1 a.m. and at 2 a.m., that babysitter is going to call the police. And they're going to say, I don't know what happened, but mom and dad didn't come home. And the police are going to arrive at the house and they're going to have Child Protective Services there to take those kids into custody and watch those kids until it can be determined who should be watching after the kids. And this isn't to say anything negative about Child Protective Services. I think that they're doing the most with what they have available to them. But I can tell you as a father of 4, I don't want my kids to have to spend any time with Child Protective Services. And that's what makes short-term guardianship so important. Having a plan in place so that there's someone who lives within 30 minutes of the kids who can come and collect them and has the legal documentation that says they have the right to stay with the kids. That's extremely important and extremely important to any estate plan for somebody with minor kids. Equally important, or perhaps even more important, is making sure that you have long-term guardianship in place. And long-term guardianship nominations mean who's going to take care of those kids until the age of 18. If you don't have that written down, if you don't have that recorded and legally documented somewhere, then there's going to be a judge who's going to be deciding what's in the best interest of those kids. And I can promise you that you're probably not going to like that judge's decision. You're not going to be around to see it, but theoretically, you're not going to like that judge's decision because that judge doesn't have the same view of your kids, the same understanding, the same knowledge of where they're going to flourish as you do. As the parent, you really have that information. You know what's best for those kids. You know where they're best going to be raised. And that's why it's so important to make sure to make those long-term guardianship nominations so that the person you want watching after those kids and loving them and making sure that they grow and learn until the age of 18 is the person that you want. I always say you don't want Uncle Larry watching after the kids, but if Uncle Larry has a steady job and there's room in his apartment for the kids, then a judge might just decide that Uncle Larry is the right person to take the kids. But you can you can step in and you can tell the judge exactly where those kids should go, and almost always the judge will honor that. All right, talked a little bit about guardianship, but don't want to dwell on it too much because, again, I know not everybody here has minor kids. So let's talk more about the assets and about the state's plan for your assets. The state has an estate plan written for all of us, and that estate plan is a court process called probate. And a probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. So before the people that you want to have get to inherit your money, it has to go through this court process called probate. And probate is a lot of things. Probate is slow. In Minnesota, it takes a minimum of 6 to 12 months to get through the probate process. We'd like it to go faster, but it's not designed that way. It's designed to be a slow process. Probate's also expensive. And here in Minnesota, we estimate that probate costs something like 3 to 6% of the gross value of your estate. So you can imagine if all that you have is a house that's worth $400,000, and I will say, you know, for some of us, a $400,000 house is a very nice house. For some of us, a $400,000 house is certainly attainable, especially right now with the way that real estate markets are. But if all that you have is that house that's worth $400,000 already, your estimated probate cost is going to be somewhere between $12,000 and $24,000. That's that 3 to 6% range that I was talking about before. Probate is expensive. It just is, and it's involving court. And we'll actually have a chance to calculate our probate costs or our potential probate costs here in just a little bit. Probate's also public. And I'm showing you here, this is the last will of Anna Nicole Smith. And I was able to access this because wills become public. A will has to be probated. A will does not avoid probate. I'll talk about how you can avoid probate, but if you plan without a will, if you don't have any estate plan in place at all, or if you're planning with a will and that's what you're relying on to distribute your assets after you're gone, then probate is necessary. And so everything in probate becomes public. The court has an interest in everything being transparent, and that means that the will has to be published. That means an inventory of your assets at your death has to be published. And that means that the final accounting and distribution, plan of distribution, has to be public as well, which is really unnerving to people that everybody in the public is going to be put on notice to the assets that they had at their death and to who's receiving those assets now that the assets have been probated. If you don't have a plan in place, then minor kids are going to receive assets at the age of 18 and completely unprotected. And this is something that I know not everybody here has minor kids, but you can imagine if something were to happen and instead of the person that you want to receive or you want to have receiving, if something were to happen to that person before they were able to receive and it passed down to their kids, you can imagine how receiving that kind of money can be really harmful to an 18-year-old or to a 21-year-old. Receiving, you know, we all know stories about 18-year-olds who receive money from somewhere, from a grandparent or uncle or aunt or a parent who passed away, and about how difficult their life became after that, because you don't learn the financial skills that you need to have and that you should be learning at that age. And so it can be very harmful to be receiving those assets without a plan in place. Okay. Here's a chance to actually calculate your probate estate. And your probate estate is generally composed of things that don't pass by beneficiary designation. So oftentimes a retirement account or life insurance policy will automatically pass to the person that you have listed as a beneficiary on that account. And as long as that person is above the age of 18, they can receive that asset, no problem. It's not going to go through their probate estate. Also joint ownership. So if you own a home jointly with your spouse can receive that home after your passing automatically by operation of law. But if something were to happen to both of you, if you're not married or you don't have that home in joint ownership, then that would be one of your assets in your probate estate. If you have a rental property, oftentimes, again, if that's not owned jointly with someone, then that would be included in your probate estate. Furniture and household goods, jewelry, artwork, those kinds of things, collections, those would be included in probate. Automobiles are included in probate. Things like stocks, bonds, and bank accounts very rarely have any kind of beneficiary designation or transfer on death designation on them. And so oftentimes those will end up going through probate as well. And then business interests, almost always, if you own a business, that business is set to go through the probate process after you're gone, and at least for a time, be run by your personal representative that's chosen in your probate case. Adding all these things up, and again, you can just do some back of the envelope math for your own estate. You can very quickly get to 5%, which is in between that 3 to 6% that we talked about before. You can very quickly get to 5% by totaling everything in your probate estate, moving the comma over one place, that gives you 10% of the number, and then dividing that number in half. And so here you can see that's how I got 42,500. That's 5% of this total probate estate is where I got that number from. To add a little complication, I talked before about if you have a beneficiary listed on your life insurance or retirement accounts, that's great. Normally they can take as long as they're above the age of 18. But if that person is a minor, they cannot take that property. There has to be some person appointed for them called a conservator, and that conservator has to take on their behalf and make reports to the court, and it really explodes the costs of probate significantly. And so if you have life insurance or retirement accounts that are payable to a minor, all of a sudden the estimated probate costs and fees become much higher because of that extra work that the conservator is going to have to do. Okay, having said all of that about the time, cost, and public nature of probate, there is a foolproof way to avoid probate, and that's by fully funding a living trust, or a revocable living trust as it's called. And I'm going to do a little demonstration here that I like to do, and especially since we had a question earlier about creating a trust and what a trust is, I want to demonstrate exactly what a trust is. So a trust is an agreement, and it's an agreement between two parties. One party starts with some property and gives that property to someone else called the trustee. And this person who started with the property is called the settlor. They're the ones creating the trust, and they give certain rules to the trustee about how they're supposed to deal with this property. The trustee says, yes, I agree to deal with this property in the way that you've asked me to. So that's where the agreement comes. It's the settlor handing the property over to the trustee, and the trustee, who is exercising control over the property, who promises to follow the rules that the settlor, that the original person laid out for them. That's the agreement. The thing about a living trust or a revocable living trust is that oftentimes these are the same people. The same person is the one who starts with the property, and they're just handing off the property to themselves wearing a different hat, wearing the hat of a trustee. And they're agreeing to follow the rules, but guess what? They're the ones who wrote the rules. And because they're the ones who wrote the rules and they're serving as trustee, they can revoke the trust that they've put in place. They can also amend the trust that they've put in place. They can change the rules after the fact. It only becomes impossible to change the rules when the settlor dies and the trustee, who's the same person, dies, and a successor trustee steps up into their shoes. And at that point, the trust is no longer revocable. The trust rules can no longer be amended, and this successor trustee has to follow the rules and distribute the property and deal with the property in the way that the settlor asked them to, or wrote the rules down before the settlor died. Okay, so that is what a trust is. I hope that that's pretty clear. If anybody has questions about that, I hope that you'll ask them. But that's the clearest way that I've found to describe a trust. And really important in this demonstration is the fact that the settlor gives all of their property, everything that would be subject to probate, over to themselves as trustee, so that it's subject to the trust agreement. And when a new trustee steps into their shoes, there's nothing else that's hanging out that is going to be a part of the settlor's estate. Everything is going to be in the trust, and the trustee is going to be able to deal with it. And what does that look like for the different assets? Well, for things like investment accounts, it means retitling that investment account, putting a new title on it so that that investment account is actually in the name of the trust. For bank accounts, it means going to the bank and signing new signature cards so that that bank account is no longer in your personal name. That bank account is now in the name of your trust. And still, even when you do that, oftentimes you can still just have your personal name In fact, almost always, you can still just have your personal name listed on your bank account. For real property, things like your home, cabin, rental property, it means executing a deed, a quitclaim deed, to actually transfer that property out of your personal name and into the name of you as trustee of your trust, so that your trustee is able to hold on to it and follow the rules and apply the rules of your trust to that cabin or home or whatever property it is. It means transferring stock and bond certificates, and there's usually a way to do that on the back of that stock or bond certificate. If it's a paper stock or bond certificate, if it's something digital, then there will be a way to either add a beneficiary to it or a way to actually transfer it directly into the trust so that the trust is taking title to it during your lifetime. Assigning personal property into the trust, and there's a simple document called an assignment of personal property in order to do that. And then changing life insurance and retirement account beneficiary designations under the advisement of your attorney, because it's not always best to change your retirement account beneficiary designations, but changing those so that they're pointing at the trust and so that the trust is going to govern what happens to those. And I see somebody asking, if life insurance goes to beneficiaries, why is it put in a trust? And that's a fantastic question. If those beneficiaries, if you know that they're going to be there with 100% certainty, and you know that they're going to be above the age of 18, and you know that the asset doesn't have to have any kind of protection on it, that person's not going to go through a divorce after they cash the check in their joint checking account, then you might not be worried about putting it into a trust. But if you have some uncertainty about any of that, if there's any chance that that person could die at the same time or around the same time as you, if there's any chance that they could be going through a divorce or going through a bankruptcy, and you would want that asset to have some protection on it, but so that the beneficiary could go through the divorce or through the bankruptcy before they had a complete right to receive, then I really recommend having that life insurance payable into a trust where you can write out some of those rules and you can dictate what's going to happen with that life insurance proceeds to make sure that it goes to the person that you want to receive, to the beneficiary that you want to receive it. Or if it ends up going to their kids who might be minors, or if you want it to go to someone else, if they don't survive you by a certain amount of time, and oftentimes we say, at least a week. So if something happens simultaneously, it doesn't end up getting paid out to their estate instead of paid out to somebody else that you might wish to receive it, then that's why you would have the trust be the beneficiary of your life insurance over that person as an individual. That's a great question. I see someone else asking, how are married couples treated in my example? And it depends. I'm sorry. That's like the classic lawyer answer is it depends. If the married couple owns property jointly, so for example, bank accounts, if you have a joint checking account, no problem. When one spouse passes away, the surviving spouse is going to take complete ownership of that bank account. And that's true as well for a home, for example. When one spouse passes away, and we'll just assume that it's the husband because we always assume that the husband is going to pass away first. But if the husband passes away first, the wife is able to take complete ownership of the home that they had in joint ownership. Problems enter when the married couple has separate property. So if the husband owns the home and the wife has been living there, but doesn't actually have joint ownership on the home, or as I've seen sometimes, unfortunately, sometimes married couples will take as tenants in common, then whatever interest that husband had ends up having to be part of the probate estate when he passes away. So tenants in common means each owns half of the property. And so when the husband passes away, that half that he owned has to go through probate. The half that the wife owned doesn't have to go through probate, but that's small comfort when half of the house is going through probate. If the husband owned it by himself and the wife wasn't a joint tenant on the property, then when he passes away, that whole house has to go through probate. And unfortunately, there are some pretty unfavorable rules about what happens to that house especially if there are kids, the kids often will have a remainder interest in the house, making it very difficult for the wife or for whoever the surviving spouse is to sell if they want to sell that house and move to a different place, for example. I see someone asking, if I don't have a mortgage, the house is paid in full, can I sell the property to my trust, for example, $10, and use both a quitclaim deed to add stipulations and a warranty deed? I'm not sure why you would need to do that. In fact, my recommendation would be put the house into the trust. And you can do that on a low or no consideration deed, kind of like that, for example, that $10 deed that just puts it into the trust. And then you can include in that trust provisions about exactly what's going to happen to that house. But your house doesn't even have to be paid in full. If you have a mortgage on the house, still, you can make that transfer with a quitclaim deed into your trust. And there's a law, a federal law called the Garn-St. Germain Act that says the mortgage company cannot accelerate your mortgage just because you've transferred into a revocable trust. That's not an option that the mortgage company has. They can't do it. It would be against the law for them to do that. So you have the ability to put that property into the trust, no problem. I'm seeing someone else say, what about a single person without children? How can I transfer the home equity, home not paid off, to only 2 of 4 siblings? That's not a problem. And there are a number of ways that you can do that. A trust is definitely an option that you can transfer your property into the trust and then include distribution provisions in your trust so that your successor trustee, who's going to be stepping into your shoes, distributes it out to the 2 of the 4 siblings and takes care of it that way. Another way is with something called a transfer on death deed. And sometimes that's a better option for people, is to have a transfer on death deed to transfer that house at your death. It's kind of like putting a beneficiary designation on your home. And that's a good solution for a lot of people. It depends on your situation. And I actually see somebody asking, this is fantastic, does a transfer upon death deed keep a property out of probate? And the answer to that is yes. A transfer on death deed, if it's executed and recorded with your county before your death, then yes, it's going to automatically happen at your death. There's an automatic transfer that happens as long as the grantee beneficiary is alive, and you could actually include contingent grantee beneficiaries. So you can include a second grantee beneficiary in case the original or the primary grantee beneficiary dies. Then you can actually make sure that happens, like I say, just like a beneficiary designation, happens automatically at your death, and that transfer happens automatically at your death. So yes, a transfer on death deed does avoid probate. That's a fantastic question. And it is a good solution for a lot of people in a lot of circumstances. Places where it can become difficult is if the beneficiaries don't get along perfectly. If they're not going to agree to treat the property the same way, then it can lead to deadlock and it can create some real problems. And I know in particular a case where there were 3 owners of a property and it was 3 siblings, and they couldn't agree what to do with that property. And so it ended up sitting there, and somebody wanted to rent it, another person wanted to sell it, and a third person wanted to live in it, but nobody could agree. And over time, the house became dilapidated. Windows ended up getting broken, the elements were let in, and now the house has almost no value because it wasn't taken care of, and there was fighting between those 3 kids. In that situation, a transfer on death deed was not a good solution. It didn't work. And having a trust in place where it was just one trustee who got to make a decision about what happened to the house would have been a better situation for that family. But trust transfer on death deeds, it can work. Yes. Okay. I'm not seeing any more questions for just a second here. So let me tell you a little bit about estate taxes. And there is an estate tax on the federal level. There's also an estate tax here in Minnesota on the state level. Minnesota is one of the few unlucky states to actually have an estate tax, but the good news is that we have a relatively high exemption amount. The exemption amount means that you don't pay any estate tax here in Minnesota until you have more than $3 million as part of your estate. And your estate includes things like your home and rental property, furniture, household goods, automobiles, stocks, business interests, life insurance, retirement accounts, pretty much anything that you are transferring to the next generation is included in your estate and is included in calculating your estate tax exemption or your estate taxable estate. Okay, good. Still, $3 million is a very high exemption, and it means that estate tax doesn't apply to most Minnesotans. Most Minnesotans don't have to worry about it. The federal government also has an estate tax, but they have an even higher estate tax exemption. Right now, that number is something like $12.92 million, and that amount is set to be to sunset back to something like $6 or $7 million in I think 2025 or 2026. But still, it's a very high number. The federal number, if you're married, you actually get to double that number. And so you're almost at $26 million that gets to pass without any estate tax coming out of that number. It's a very generous exemption. It's higher than almost it's ever been. There was 1 year where there was no estate tax applied to any estate for that year. It was just a weird glitch year where Congress couldn't get together and pass a law governing the estate tax. But this is about as high as the estate tax exemption has ever been. In Minnesota, that $3 million doesn't automatically double, but with some estate tax planning, you can make that number double. You can make sure that it actually doubles, but it does take a little bit of work and a little bit of estate tax planning. Someone's asking here, does a trust designate guardianship for minor children, or can it designate? Should we have a power of attorney as well as a trust? We've filed our TOD already. Kids are 21 and 16. That's a great question. Guardianship is generally designated. You generally nominate your guardian in a will or in a standalone guardianship nomination document. And I happen to do both. The reason is because sometimes it takes a probate court some time to take into account the will and to interpret it and to make a determination on the guardianship nomination, whereas having a standalone guardianship nomination gets it before the court more quickly so that the long-term guardians can take the kids. So you're not going to see that in a trust. You're going to see that in a will document or in a standalone guardianship document. And a will would be a part of any estate plan. Even if you were planning with a trust, you would still write what's called a pour-over will, which essentially just says, if I have any assets in my personal name when I die, put those assets into my trust. So a will is a part of any estate plan because a will helps you to plan to cover things and to make sure to cover things like guardianship and to cover things like if I forget to put something into my trust, making sure that it gets into my trust after I'm gone. But this other question, should we have a power of attorney as well as a trust? The answer to that is absolutely. You want to plan for incapacity as well as planning for death. And so having a power of attorney in place allows you to plan for if something happens and you're in a coma before you pass away, then you need to have somebody who can access your accounts, who can access and deal with paying utilities and paying for the house and that kind of thing. And that's the power of a power of attorney. It's a financial power of attorney giving access to your finances before you actually pass away. There's another document, healthcare directive, that's very important as well. But yes, it is necessary. I'm glad to hear that you have the TOD filed already, although having kids who are 21 and 16, I'm a little curious about who the beneficiaries are on that TOD. And if the 16-year-old is a beneficiary on that TOD, you may have a problem if something were to happen in the next 2 years. I think it's unlikely that anything's going to happen, obviously, but you might have some concern and you might want to get that addressed or get that fixed so that the kids don't end up, so that nobody ends up taking that property or trying to take title of that property before they're of age. And I see someone else asking, what happens if your trust is foreign? And I take that to mean foreign as in executed in a different state or subject to the laws of another state. And that's what happens, is it's subject to the laws of another state. And so oftentimes I will write estate planning documents for people who are living here in Minnesota but considering leaving. And if that's the case, then when they leave and they go to a new state, I advise them to have their estate plan reviewed and to make sure that everything is up to snuff and makes sense in their new state. But if not, then their estate plan would be followed by the laws of Minnesota and would still be subject to the laws of Minnesota. It's included in all of the estate planning documents that I write. It's to be governed by the laws of Minnesota. The reason that we have it reviewed and the reason that we have it updated is because some states give more favorable benefits or more favorable laws that we might want to take advantage of. And it's also simpler for the courts in other states to follow the provisions of their own state instead of having a Minnesota trust and having a North Dakota, court or New York court trying to follow the laws of Minnesota is much more difficult for that court. So, man, great questions tonight, everyone. Thank you, and keep them coming because I love answering them. So I was talking a little bit about estate tax. Once you get above that exemption amount, these are the rates that kick in. The federal rate is up to 40%. And so you really want to make sure that you have some planning done if you have over that 12.92 million. Again, I know that applies to very few people. In Minnesota, the rate starts at 13% and goes up to 16% once you get above that $3 million exemption. So on your $3 million and first dollar, that tax rate starts kicking in at 13 cents on the dollar and goes up to 16 cents or 16%. Someone's asking, if I own a company, LLC, should we amend articles to add kids as beneficiaries and 21 years old and 16 years old? Actually, there are some really great ways that you can transfer a company LLC. One is by putting it into the trust and having the trust hold onto it. Another is by using what's called a transfer on death designation. And there is a law that you can do a transfer on death designation on membership interest in an LLC, but you should talk to an attorney about how to do that. It can be really difficult to put that into the articles or to add kids as beneficiaries. An LLC agreement just there isn't, to my knowledge, a really good way to do that. The best way is you take those membership interests, which is that ownership. It's like a stock, kind of like a share in a corporation, and you apply to that membership interest what you want to have ultimately, who you want the beneficiary to be. And that's where that transfer on death registration for that membership interest, or putting that membership interest into a trust and then having the trust dictate what's going to happen with those membership interests after you're gone. That's where I would recommend planning for something like a company or LLC. Are North Dakota trusts best pertaining to taxes or in any way? I don't know about North Dakota trust, but I know that South Dakota has some extremely favorable trust provisions. I believe that Alaska, Utah, and Nevada as well have some extremely beneficial trust provisions. But as far as taxes, you are subject to the taxes of the state that you live in for 6 months plus 1 day. And I've actually seen this, the Department of Revenue used to clock our clients and check in on them every day to see if they were actually living in Florida for 6 months and 1 day, or if they were living in Minnesota for 6 months plus 1 day to determine if they were going to be subject to a state tax here in Minnesota. So as far as taxes, I don't know that there's a big distinction, but I know that South Dakota has some very good provisions about length of the trust and that kind of thing. For most people, it makes the most sense to have the trust be located in the state where they're residing, in the state where they live, and have it be subject to those laws. Do I advise as an option to have a bank be a trustee? This may be due to someone not having a successor trustee to properly execute the trust. There are good reasons to have a corporate trustee. Oftentimes, I recommend having what's called a professional fiduciary serve as trustee. And a professional fiduciary is somebody who's paid hourly, something like $150 an hour, which I know sounds expensive, but compared to a corporate trustee or a bank trustee that can charge 1% to 2% of the total trust amount each year, having a professional fiduciary is often less expensive than having a bank or a corporate trustee. But yes, absolutely. There are some really good reasons to have a third-party trustee, to not have it be a family member, especially if you're getting into some nuance like a special needs trust or a supplemental needs trust for somebody that would benefit from that. It can be very difficult for a family member who's not an attorney to follow through and execute on all the requirements of an SNT, and it's often beneficial to have a third-party trustee or somebody like a professional fiduciary take care of that. If you're not legally married and your home is only under one spouse, will a transfer on death deed be enough to protect the home from going to probate? Yes, it would. Also, having ownership of the home jointly, you could transfer it so that it was in joint ownership if you wanted to, but keep in mind, then you're splitting it and it's 50-50 now. Otherwise, a transfer on death deed is only effective at your death, and so you're not immediately taking ownership of half of the house. And then after the person passes away, a transfer on death deed would be just like a beneficiary designation. It would automatically go to that other partner so that they would receive the asset and be able to continue living in the home. And that would be a good solution if that was the case. If that's what the couple wanted, was to continue to have the survivor continue living in the house, then that would be a good way to handle it. However, there are specifics and there are facts that I'm not, that I don't necessarily have here. So I'm not giving you legal advice. I'm just saying that yes, in that hypothetical, it sounds like that would be a good solution. If you have questions about that and you want me to actually evaluate the specifics, then I hope that you'll reach out to me and schedule an appointment with me so that we can look at that together. If the mortgage is only under one spouse, will the surviving spouse have to refinance or purchase the loan under their name if the owning spouse passes? So, but this person who asked it about legal marriage asked this question as well. And so if they were actually spouses, then the surviving spouse is not going to have to refinance or purchase the loan. Excuse me, they're going to be able to do something called assume the loan and have the same terms, have everything be subject to the same terms. This is also true to my knowledge, for most beneficiary designations. And so having a transfer on death deed, having an heir or an inheritor take ownership of property, I believe that heirs and beneficiaries also get to assume the mortgage that's in place when the original person passed away, but I don't know specifically, and I would have to do a little bit of research on that to verify that. It definitely hasn't been an issue with rates, when rates were as low as they were, but now that rates have ticked up and there are people out there with 2.5% or 3% mortgages, when most mortgage companies are selling rates that are 6% or higher, that may be an issue now that would be more pressing. But generally, a spouse is able to assume the loan or assume the mortgage and take on those payments just as their deceased spouse did. Another question here: if my mom's name is on dad's bank accounts, home, it's paid off, and savings account, etc., and dad has not taken her name off since she's passed a few years back, could he still write out transfers on death deed to his daughters? Or does this spell out probate? Now, that's a fantastic question. There's a way for your dad to clear title on those, doing things like bringing death certificates to the bank and showing that that the wife is no longer living is the easiest way to clear those types of title. For the home, there's something called an affidavit of identity and survivorship that would need to be filed in order to show that title was now in his name alone as the original joint owner of the house, now that the other joint owner is no longer living. And after that affidavit of identity and survivorship was filed, then a transfer on death deed could be filed so that the house was going to his daughters, or again, the house could be put into a trust and could have the trust distributed out. Don't give up hope. There's good planning that you can do, and that's there's still very much good planning that you can do in this case. And I encourage you to have somebody take a look at it and see what can be done. Okay, let's talk a little bit about unclaimed property. Does anyone know how much money is in our state, Minnesota Department of Unclaimed Property? It's over $700 million. And a big part of the way that the money gets there is somebody passes away and their heirs weren't aware of all of the assets that they held. And maybe there's a bank account or maybe there's a retirement account somewhere that they failed to collect, and it ends up with the State Department of Unclaimed Property then. It's very difficult to claim at that point. And I think that this is something that's really important that not a lot of estate planning attorneys talk about or address. But I can tell you, as somebody who's still growing my assets, who's still growing the estate that I want to give my kids, I want to make sure every dollar goes to them or goes to their care after I'm gone, and make sure that all of it is used to raise them into the human beings that I want them to be. This is really cool. You can make your living trust a real treasure chest, say that 10 times, by building in asset protection over their inheritance. And asset protection means you can protect their inheritance from things like a divorcing spouse or being sued or having to file for bankruptcy. You can protect the money from those things by building in this asset protection. So this is something that's really fantastic, but you got to work with an attorney in order to build that asset protection in. It's not something that they can give themselves either. There's not a first person asset protection trust. Sometimes people will try and build them and try and do things to create first person asset protection trust, but it's very difficult and very expensive, costing over $20,000, sometimes over $40,000 to even attempt to build a first person asset protection trust. But you can build it in to the inheritance that you're giving your kids for much less than that. Planning for incapacity. This person on the screen is Terry Schiavo, and many of us probably remember Terry's case in the early 2000s, in the mid 2000s. Terry suffered a cardiac event and was in a vegetative state, and her family disagreed about what should happen to her. Her husband thought Terry wouldn't want to live in this vegetative state. She would want to be allowed to pass. She would want life support removed and would want to be allowed to pass. Her parents, Terry's parents, thought that although she was in this vegetative state, she was still showing some signs of interacting with her surroundings, and that Terry would want to be kept alive, and that a miracle was still possible, that Terry could still come out of this. Well, there was a series of court cases all the way up to the Supreme Court of the United States, and it was eventually decided that life support should be removed from Terry, and Terry did pass away after life support was removed. All of that conflict, all of that uncertainty can be addressed, and you can put your wishes into a healthcare directive to make sure that it's clear to your family exactly what you would want to have happen if something happened and you were in a vegetative state like Terry was. So all of the things that we've talked about today have probably led to this question in your head. What can you do today to do the right thing for your family, and what should it cost to plan right? And if something that I've talked about, if the cost or public nature or time sink of probate, or concerns about minor guardianship, short-term guardianship or long-term guardianship, concerns about estate taxes have resonated with you, concerns about unclaimed property or having your healthcare wishes written down for you. I know a lot of the questions here today have been about probate, and I feel like probate's probably a big concern to everybody here. If that is a concern for you, then you really have these two options in order to create a plan. You can either try to do it yourself, or you can work with a lawyer. And keep in mind, not all lawyers are the same. So how do you decide between these? How do you choose whether you would benefit from working with an attorney? And keep in mind, obviously I'm biased. I am an attorney here in Minnesota. And this is what I do. I create estate plans for people. But I'd like to provide some guidance in when I think it makes sense to work with a lawyer. If you own more than just your personal belongings, if you own more than just your cars, clothing, jewelry, furnishings, then your estate is likely to be subject to probate. And if your estate is likely to be subject to probate, then you would probably benefit from working with an attorney to try to avoid it or minimize the impact that that probate is going to have on your family. If you want to ensure that the people that you love stay out of court and out of conflict, and that those people have someone to turn to when something happens to you, then you should work with an attorney. If you want a kids protection plan, which includes both the short-term guardianship and the long-term guardianship for those minor kids, or you want to avoid probate, or you want to avoid or minimize the estate tax burden that your estate is going to be subject to, or if you want to protect the inheritance that you're giving to the people that you love with that asset protection, then you have to work with an attorney. Those are things that only an attorney can do. And if you want to guarantee that your plan is going to work when your family needs it to work and not have the uncertainty of whether that plan is going to be the right thing for your family when they need it, then you should work with an attorney. And really, if you want to give your assets to someone other than your kids, that's what the state of Minnesota thinks that you want to have happen, is that all of your assets going to go to your kids. But if you don't have kids, or if your kids wouldn't be the right person to receive, then you should really work with an attorney to make sure that those assets are going to the people that you want to receive them in the way that you want them to be received. And here's something that I like to share. It's a little do-it-yourself story from my own life, because believe it or not, I am a big believer in trying to do things on your own, to do things yourself. And in this case, it was putting fishing line on a fishing rod and reel. That I was going to take my son fishing, and we had gotten a couple of new rods and reels for the new season. And they had come to us without any fishing line on them, not a problem, just ordered a reel of fishing line and followed an instructional on YouTube, thought that I had everything going exactly right and reeled the fishing line up on the reel. But as soon as I went to cut the line, I must have done something wrong, because that line just started jumping off the reel and was all over the table in front of me. And if anyone knows what I did wrong, please share with me in the chat, because I still don't exactly know, but I screwed something up, okay? In that case, it was a do-it-yourself disaster, but it was a do-it-yourself disaster that cost very little. The fishing line that I lost, that was so tangled that I couldn't do anything with it anymore, I was able to snip it off, and it was maybe 30 cents worth of fishing line, not very expensive. And I was able to see immediately that whatever I had done, I had screwed up, and this wasn't going to work. So I had very immediate and very tactile feedback right away that I was going to need to fix something. And my son and I were still able to go out fishing that morning. I just cut off any of the amount that was tangled, and I was able to use the rest of the fishing line without a problem. And we were able to get out there and go fishing. Estate planning is not that way in so many ways. Estate planning, you're not going to know if your estate plan worked or didn't work, because you are going to be gone. And you're not going to be able to clean up the mess, because you are going to be gone, and your family is going to be hurting, and they're going to be grieving. And it's expensive. It's not going to be 30 cents of fishing line. It's going to be very expensive and involve attorneys in court, and likely conflict and fighting in your family in order to resolve whatever happened in your estate plan that made it not work the way that you wanted it to work. It is a dangerous do-it-yourself project. And that's why I recommend working with an attorney to get your estate plan written. Keep in mind, when you're choosing an attorney, not all attorneys are the same. And I want to bring you back to this quote. Again, it was not said about me, but was said about another estate planning attorney that a family member had a bad experience with. Someone has to graduate at the bottom of the class. Again, I don't think it was this attorney's knowledge or their skill in law school or their intellect or anything like that that caused this family member to have such a negative experience. I think it was the model that they were planning under. And I call it planning for death. Planning for death is the typical estate planning experience with a typical estate planning attorney. And this is what it looks like. You're going to get form documents and the attorney is going to fill your name in a couple of spots. It's not going to be tailored to your situation. They're not probably going to involve you much in the decision-making process. They're just going to kind of size you up when you walk in and fill in your name in a few spots. Those documents are going to lead you to believe that they're kind of set it and forget it documents. You're going to put them in the bottom of a drawer, and you're probably not going to look at them again until you're gone. When you're not going to look at them, your family's going to look at them, and maybe it'll match your current circumstances, maybe not. But more likely than not, more often than not, they don't match what you actually want to have happen. Typical experience isn't going to keep your money out of the Minnesota Department of Unclaimed Property. It's just not something that most estate planning attorneys spend time and put attention on. Typical experience may avoid probate, but it may not. In fact, a lot of estate planning attorneys also practice probate, and they end up benefiting when an estate plan doesn't work out the way that you want it to, and they end up getting to bring that estate through the probate process after writing it. I can tell you, I do probate. I don't like doing probate. I especially don't like doing probate for my clients. And so unfortunate reality that sometimes it does benefit the estate planning attorney, but not something that it's definitely something that I avoid, not something that I want to be a part of. Typical experience probably isn't going to keep your family out of conflict. And this just family dynamics aren't something that most estate planning attorneys get into. They're very focused on assets and they're very focused on maximizing asset transfer without focusing on the different family dynamics and making sure that your family is well cared for. Typical experience is only going to focus on money, not your stories or your values, those intangible assets that are often lost. It's going to leave assets to heirs unprotected without that asset protection that is so valuable, protecting the assets from divorce and bankruptcy. Typical experience is not going to provide ongoing legal guidance. And a big reason for that is the typical estate planning attorney charges hourly fees. And so you're not going to want to call that attorney and tell them that you just bought a new house. You're not going to want to call the attorney and tell them that your first grandchild or your first great-grandchild was just born and ask them questions about what does this mean for my estate? Because you know that you're going to be paying their hourly fee for that phone call. Typical experience is not going to adequately protect minor kids. Oftentimes they will make that long-term guardianship nomination in the will, and that's all that they will do. They won't provide a standalone guardianship nomination or a short-term guardianship nomination. That's so important. And it's really going to leave you with this question: is this plan going to work for my family when I'm gone or not? And that's never a question that you should have after you've worked with an estate planning attorney. Planning with me is totally different. I call it planning for life. It's a totally different experience. I charge flat fees, and I work with you to choose the fee that works best for you. It's going to work to get you the plan that's best for your family and fit your finances in the best way possible. Planning with me means keeping your money out of the hands of the state. I think that that's so important that every asset goes to the people that you want it to go to. And so we actually create an inventory of your assets to make sure that nothing is lost to the Minnesota Department of Unclaimed Property. Planning with me protects the kids totally, both in the immediate, the short term, and the long term. It means keeping your family money out of court and conflict. Planning with me means knowing that you've made the right decisions because I work with you. I provide the education so that you know what the decisions are and how they're going to affect your family. And then I empower you to make those decisions so that you can make them yourself. Working with me means that you can protect the family money from outsiders, from things like a divorcing spouse or a creditor suing or forcing a loved one into bankruptcy. Planning with me means a lifetime of guidance and protection. I include all future calls and emails in the flat fees that I charge. And that way, you know that you can pick up the phone and you can tell me about the new home that you just bought, your dream home, and how is this going to affect our estate plan? Or you can pick up the phone and tell me about your new grandchild and ask questions about how is this going to affect my estate plan? Or just ask simple questions like, we're opening a new bank account. Can you remind me the name of my trust so that I take title or that I open this bank account in the right name? I want to be available to you. I want to be able to answer those questions to you. And I don't want you to have to worry about hourly fees. I want you to feel like we can have a relationship where you know that I'll pick up the phone and answer your questions for you. Planning with me means that your plan is going to work when your family needs it to work. And really, it's a gift that you're giving to the people that you love the most. So knowing that, knowing the difference between working with a typical estate planning attorney and working with someone like me, what should putting together an estate plan cost? Well, keep in mind, if all you have is a house that's worth $400,000, and I know for a lot of us, that's a very nice house. For some of us, that's already where we're at, or for some of us, that's where we were a while ago. Whatever state you're in, if all that you have is a house worth $400,000, this is already going to save your family $12,000, which is that 3%, that lower bound probate fee estimate for what probate is likely to cost. If you have assets over $3 million here in Minnesota, then this planning is going to save at least 13 cents on the dollar for every dollar in excess of $3 million. A typical death plan with a typical death planning attorney or a typical estate planning attorney is going to cost a minimum of $1,500. If they're charging you anything less than that, you're really getting bare bone planning that is not taking into account nearly anything. It's just putting your name on documents. That $1,500 minimum plan from that typical estate planning attorney is going to be almost guaranteed not to keep your assets or your family out of court or out of conflict. It won't ensure your assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your money, not your kids' immediate care or your values, your insights, stories, or experience. Those most intangible, those most valuable, tangible, intangible assets that are often the most lost assets. The alternative is you can plan with me, and I'm a personal family lawyer, and you're likely to pay somewhere between $2,000 to $8,000 for that plan. But again, I'm going to educate you and empower you the entire way along so that you build a plan that really matches to the needs of your family and takes care of your family in the way that you want them to be taken care of. And I want to make this really easy for you. And in fact, I'm going to come over here. I know that I've got some questions coming in and I will get to them, I promise. I want to answer everybody's questions, but I want to copy and paste the link, and hopefully everybody can see that in the chat right now, the link to my calendar so that you can take a look and get on my calendar if you want to. I want to offer the initial meeting to you absolutely free. And that meeting is a family wealth planning session. It's a 2-hour-long meeting with me. The first hour is all about educating you and empowering you to make the right decisions for your family. And there's a little bit of homework that I'd ask you to turn in before we actually meet. I hope that you will, so that you can get that absolutely free with me. But that family wealth planning session is a no obligation, again, completely complimentary, because I want to talk to the specifics of your situation. And I want you to have information about the specifics of the situation and what the state is actually has planned for you, so that you have a complete picture and you know whether you would benefit from working with an attorney like myself and putting an estate plan together. Additionally, I want to give you $250 towards the estate planning package of your choice if you reserve your appointment before the end of the week. And what I mean there is by the end of the day Saturday, if you click through and get on my calendar, the appointment doesn't have to be before the end of the day Saturday. In fact, as you click through to look at the appointments that are available for a family wealth planning session, you're going to see that I am booked out for all of February. I believe that I'm probably booked out for, if not all, most of March right now. In fact, I think there's 1 day left in March. There are a few days left in April, and a lot more availability in May and June. And the reason for that is I only accept a specific number of clients each month in order to ensure that I'm giving the attention and care that each of my clients deserves. And so I really limit the number of meetings that I'm willing to hold in any given month, just to make sure that you get the attention that you deserve. But I want to give you that $250 off the estate planning fees of your choice. And this is my way of incentivizing you to take the next step. This is a momentum thing. Estate planning is a momentum thing. I know most everyone said at the beginning of our time here tonight that they do not have an estate plan in place. And this is a big part of the reason why, is this takes momentum. This is hard to talk about. It's hard to spend time on. It's hard to invest in. I understand that, but you have taken a great first step here. And I want to encourage you to continue moving forward and to get a great estate plan in place for the people that you love. And that's why I want to try and break down all the barriers that I can. I want to give you our initial meeting for free. And I'm, again, not even making any obligations to continue. I want you to have that meeting for free so that we can meet and talk about your specific situation and see what would benefit you, what would give you peace of mind, and what would benefit your family from a planning perspective. And if I'm the best option for you, then I hope that you'll work with me, and that in that case, I would take $250 off the plan of your choice. And what does it look like working with me? Overwhelmingly positive. Here are a few of the things that my clients have said, and I'm not going to read through these because it would embarrass me to no end. But I know that I have some email or some questions here, and I want to direct my attention to those and make sure that I answer them before we get off the call tonight. I see somebody saying, I am looking to get more information on guardianship for an elderly parent. Do you have any recommendations? Yeah, that's a really good question. You're really looking for likely an elder law attorney, and I do some of that work. And I do some work in guardianship and planning for nursing home care. And so I really recommend that you talk to an attorney in order to get more information on guardianship and whether guardianship is something that's necessary, is a necessary step right now, or if there are other things, if there are other avenues that you can pursue, things like a power of attorney, healthcare directive, in order to help that person make decisions if they still do have some capacity to make those decisions. Then having something like a healthcare directive or power of attorney is definitely a lower barrier and easier way for them to make decisions. As far as resources here in Minnesota, and I believe, resources here in Minnesota, there is a senior linkage line is a resource that we have here that may have some information on that. I believe that the Minnesota Attorney General also puts out information on guardianship for elderly folks, and you can find some information on that. But I encourage you to reach out to me. And even if it doesn't make sense to you to create or to start a complete meeting with me, I hope that you'll sign up either for 15 minutes or just email me after, and I can take a look and see if I can find some resources specific to that for you. See someone else asking, can you speak about putting homes and land in an irrevocable trust versus revocable or revocable? Irrevocable or irrevocable. Yeah, that's how that's okay. So there are two types of trust. There are many types of trust, but there is a trust called revocable, and that's what I've been talking about tonight. A revocable trust can be revoked. This person is asking about irrevocable trust or irrevocable trust. And an irrevocable trust cannot be revoked. It cannot be amended. Once you put it in place, it's on rails, and it's just going to carry through and do exactly what it was set out to do. The rules that you wrote at the beginning are the rules that are going to apply to this irrevocable trust. Okay. And there is some planning that you can do with an irrevocable trust, especially around nursing home care costs and the costs of long-term care. What you can do with an irrevocable trust is you can take and you can put property into that irrevocable trust, and it starts what's called the 5-year timer, the 5-year look back period for medical assistance in this state or Medicaid. And so it starts this timer because it's effectively a gift that you can no longer take back, and you can't change the rules on it. You can't revoke it. So it's essentially a gift. It's out of your name, and it started that 5-year timer. So that's typically what irrevocable trusts are used for. There are other things that it can be used for. A lot of tax planning. You can use irrevocable trust. It's really a specific, factually specific situation. And so if you have questions about that, if you have concerns about nursing home care costs, if you have concerns about taxes that you think could be addressed by using an irrevocable trust, I just hope that you'll reach out to me after the fact and we can talk about that. And then there's a little bit more of this. This will be in case I don't want successor family members to sell the generational land or home. Oh, I see. So you are even thinking, how can I keep this in the family for more generations? And actually, that's possible to do with a revocable trust, at least for a certain amount of time. Here in Minnesota, we have limits on the amount of time that a trust can stay in existence. You can't have a perpetual trust or an everlasting trust here in Minnesota. The amount of time that a trust can last is limited to 90 years from the date of creation, or 21 years plus an age in existence during the time of execution. And that's super confusing, but essentially what it means, it's very difficult to keep generational land in the family using something like a trust. There might be some other ways to do it. You might be able to do something like an LLC and restrict transfer and restrict who can actually receive the shares of that LLC going forward. So there are likely some ways that you can deal with that. Or if you're just worried about the next generation or 2 generations from now, a revocable trust and using the maximum duration here in Minnesota might be enough to take care of that. Something else that you could do is look to some of the other states, like South Dakota, I believe, has a 250-year trust or something like that. Nevada may even have a perpetual trust. But I would also ask you to evaluate and see if that's something that's how important that is to you when 250 years, that's likely you're making decisions about someone that you likely never to have met at that point. And so think about that a little bit and think about this is, again, something very good to talk about with an estate planning attorney, and I'd be very happy to talk with you about that. Are group legal plans through your employer as thorough? And unfortunately, the answer to that is no. That group legal plans generally are kind of the lowest level of planning. They're a little bit better than something like darn it, now it's escaping me. Generally, it's very foundational will-based planning. They're not planning to help you avoid probate. And the reason is they just have to get as many people through as possible, that they're just creating kind of form plans and putting them in place for people. And that's how they take care of people, because it's they just don't have time to go into the depth. Oftentimes you can upgrade in those legal plans, those group legal plans, so that they will create a trust for you. Sometimes you can upgrade so that those trusts will include things like asset protection. But oftentimes the attorney that you're working with there is going to be the typical traditional estate planning attorney, not somebody who is trained as a personal family lawyer as I am, and not as thorough, unfortunately. And then there's a question here: are you able to come up with anyone who can assist me in my state? And I just hope that you'll reach out to me by email, so that I believe that we connected earlier as well, and you can reach out to me that way again, so that I can provide a connection in the state where you are. I haven't been able to come up with anyone, but I will, and I know where I can access people and where I can come up with someone for you. Okay, and that goes for everybody. If anybody is outside the state of Minnesota, again, I really practice here in Minnesota, but I have access and can reach out and find people in other states if you want. Okay. I'm seeing that that some people have signed up, and I love it. I love seeing that. I'm so happy to see that people are taking advantage of the family wealth planning session offer, and they're going to be taking advantage of the $250 towards a plan of their choice as well. It's fantastic, and I hope that more of you will take a look at my calendar and get your family wealth planning session booked so that we can meet and get things figured out for you. Again, the family wealth planning session, I'm offering it absolutely free because I believe that you should be able to evaluate what the state's plan is for you and for your family and your assets, and make the choice at that point if it makes more sense to hire an attorney to help you plan your estate. If it's something you think you can do yourself, or if you're already happy with the state's plan, I just want to be a part of the conversation with you and help to give you some guidance in exactly what the state's plan is for you. I'm not seeing any other questions coming in right now, and so I think I am probably going to call this to a close. We have exceeded our 1 hour allotment, and I want to thank everybody for staying with me, and I hope that everybody was able to get their questions answered and learn a little bit about estate planning here. Thank you for joining me tonight. Thank you for asking your questions. If you had a question, it's very likely that someone else had the question, and so thank you for bringing your questions here tonight and getting them answered. Again, I hope that, will we get a recording? Yes, the answer to that is yes. I'll be sending out the recording. I'm going to try and send it out here tonight to everybody who attended, and even to people who only registered. I'm going to try and send out the recording to them as well. So, all right. Thank you again, everybody, for joining me here tonight. Really appreciated everybody being on the call. And again, I hope to meet with you soon. I hope to be able to help you with this. Have a great night.